What are the ethical boundaries for a criminal lawyer in defending a client that he or she personally believes is truly guilty? Should they put aside their personal opinion in order to give the defendant a right to a fair trial, or should they refuse to take on the client?
It would be wrong to refuse to take on a client because of your personal belief in the client's guilt. If you believe the client, if you know the client is guilty, you can't put him on the witness stand. You can't allow him to lie, and you can't put on false witnesses. But you must challenge the government's case in every ethical and lawful manner.
When you say that you know that the person is guilty, I mean, how would you know? Doesn't it really just...
Sometimes they tell you. Other times the evidence is so overwhelming that there's no way out. For example, there might be a videotape of him confessing or a videotape of him doing it.
So your ethics as a criminal lawyer is to defend the
client and put on the best possible case you can. Challenge the government and put on the best case you can, consistent with ethics and legality.
Okay. Would you say that there's any difference between the beginning of the case and the middle? What I mean is, if the attorney took on the client thinking the defendant was innocent, and something developed in the middle that made him change his mind,
that makes it even harder. But in my view, a lawyer should not turn down a case because he personally believes the client to be guilty. Every criminal defendant is entitled to a defense.
Okay.